Every society needs rules. Without rules, there is only chaos. Law is the backbone that holds a community together, ensuring that people can live with a sense of security and fairness. In the vast and ancient land of India, this concept of law is as old as civilization itself. It was not just a set of commands from a king. It was a way of life, a moral compass that guided every person from birth to death. This ancient system, known as Dharma, was about righteousness, duty, and cosmic order. It was a complex web of social norms, religious duties, and legal principles that aimed to create a harmonious and just society. The idea was simple. If everyone followed their dharma, the world would be a better place. But as we know, life is never that simple. The earliest whispers of Indian law come from the Vedic period, a time of hymns and rituals. The Vedas, the most ancient Hindu scriptures, laid down principles of conduct and morality. But the real codification began with the Dharmasutras and later the Dharmaśāstras. The most famous of these is the Manusmriti, or the Laws of Manu. This text was not just a legal code, it was a comprehensive guide to life. It detailed rules for kings, for different social classes, varnas, for family life, and for individual conduct. It covered everything from marriage and inheritance to crime and punishment. The punishments were often severe, designed to deter wrongdoing and maintain social order. The king was seen as the ultimate dispenser of justice, but he was expected to rule according to Dharma, advised by learned Brahmins. As time went on, new philosophies emerged that challenged the old ways. Buddhism and Jainism, with their emphasis on non-violence, ahimsa, and compassion, brought a new perspective to the concept of justice. Buddhist kings like Ashoka the Great sought to rule with Dhamma, a principle of ethical conduct and social responsibility. He inscribed his edicts on pillars and rocks across his vast empire, promoting tolerance, welfare, and fairness for all beings, not just humans. These philosophies softened the rigidities of the older systems. They argued that justice should be about reform, not just retribution. They influenced kings and common people alike, creating a more compassionate legal culture where the welfare of the subject was considered a paramount duty of the ruler. Even in these ancient times, the system was not monolithic. Different regions and communities had their own customs and traditions, which were often recognized by the rulers. Local councils, known as kulas, family councils, shrenis, guilds of merchants, and pugas, village assemblies, played a crucial role in resolving disputes. These bodies understood the local context and could deliver justice that was swift and accessible. People often trusted these local councils more than the king's court. This decentralized system showed a deep understanding of India's diversity. It allowed different communities to live by their own rules, as long as they did not fundamentally challenge the overarching principles of Dharma. This blend of centralized authority and local autonomy was a hallmark of ancient Indian law. The arrival of Islamic rulers in India, beginning around the 12th century, marked a new chapter in the country's legal story. This was not just a change of kings, it was the introduction of a completely different legal philosophy. The new rulers brought with them Islamic law, or Sharia, which was based on the Quran and the teachings of the Prophet Muhammad. This created a complex situation. A new legal system was imposed on a land that already had a deeply entrenched and ancient system of its own. The challenge was immense. How could these two different worlds coexist? The rulers had to find a way to govern a vast non-Muslim population while adhering to their own religious laws. This led to a period of legal innovation and adaptation. The sultans of Delhi and later the Mughal emperors established a formal judicial system. They set up a hierarchy of courts, with the sultan or emperor at the very top as the highest court of appeal, the fountainhead of justice. Below him were the qazis, judges who were experts in Islamic law. The chief judge was the Qazi-ul-Quzat. These courts primarily administered Sharia law. For criminal matters, Islamic law was generally applied to everyone, regardless of their religion. This meant that crimes like theft, robbery, and murder were judged according to the principles of Sharia. The punishments could be harsh, reflecting the legal traditions of the time. This uniform criminal law was a way for the state to assert its authority over all its subjects. However, when it came to personal matters, the Islamic rulers were often pragmatic. They understood that forcing an alien law upon people's private lives, matters like marriage, divorce, inheritance, and adoption, would lead to widespread resentment and conflict, so they allowed a dual system to operate. While Muslims were governed by Sharia in all aspects of their lives, Hindu communities were allowed to follow their own personal laws, the Dharmaśāstras. Hindu pandits and village panchayats continued to resolve civil disputes within their communities, just as they had for centuries. This policy of non-interference in personal laws was a crucial factor in maintaining social stability in a diverse empire. This dual system created a unique legal landscape. On one hand, you had the formal, state-sponsored Islamic courts dispensing justice based on a written code. On the other hand, you had the informal, community-based system of Hindu law, rooted in ancient texts and customs. This was not always a neat separation. Sometimes non-Muslims would voluntarily bring their cases to the Qazi's court, perhaps hoping for a quicker or more favorable judgment. The Mughal emperors, especially Akbar, tried to create a more integrated system. He promoted a policy of sul-e-kul, or universal peace, and he attempted to introduce principles of natural justice that could be applied to all. But the fundamental duality of the legal system remained a defining feature of this era. When the British East India Company began its transformation from a trading entity to a ruling power, it inherited this complex legal tapestry. Initially, the company was cautious. It did not want to disrupt the existing systems too much. The early British administrators continued the Mughal practice of applying Islamic criminal law and respecting the personal laws of Hindus and Muslims. Warren Hastings, the first Governor-General of Bengal, famously declared in his judicial plan of 1772 that in all suits regarding inheritance, marriage, caste, and other religious usages or institutions, the laws of the Quran with respect to Mohammedans and those of the Shastra with respect to Gentus, Hindus, shall be invariably adhered to. This was a pivotal moment. It formalized the separation of personal laws, a decision that has shaped the Indian legal system to this day. As British control expanded and consolidated into the British Raj after 1857, their approach to law became more ambitious and systematic. The British were driven by a desire for uniformity, certainty, and what they saw as modernity. They believed that the existing Indian laws were chaotic, arbitrary, and in need of reform. They embarked on a massive project of codification, aiming to replace the jumble of traditional laws with clear, written codes based on English legal principles. This was a legal revolution. It introduced concepts like rule of law, equality before the law, and an adversarial system of justice, where two opposing sides present their case to a neutral judge. This was a stark contrast to the inquisitorial systems of the past. This era saw the birth of some of India's most important laws, many of which are still in force, albeit with amendments. The Indian Penal Code of 1860, drafted by Lord Macaulay, provided a uniform criminal law for all of India. It was a masterpiece of legal drafting, clear and comprehensive. This was followed by the Code of Criminal Procedure in 1861 and the Indian Evidence Act in 1872. These codes replaced the existing Islamic criminal law and introduced English rules of evidence and procedure. For civil matters, the Code of Civil Procedure, 1908, and the Indian Contract Act, 1872, were enacted. These laws brought a sense of predictability to the legal system, but they also swept away centuries of indigenous legal tradition. But even as the British imposed their own legal framework, they consciously left personal laws untouched. They kept their promise from Hastings' time. The personal affairs of Indians, the sacred circle of family, marriage, and inheritance, remained governed by their respective religious laws. So, while a Hindu and a Muslim would be tried under the same Indian Penal Code for theft, their inheritance disputes would be decided by completely different sets of rules. This created a peculiar hybrid system, a unified public and criminal law coexisting with a fragmented personal law. This legal pluralism was a political compromise, but it sowed the seeds of future debates, particularly the call for a uniform civil code that continues to be a sensitive topic in modern India. The struggle for India's independence was not just a fight for political freedom, it was also a quest for self-determination, for the right to create our own laws and build a just society. As the British Raj weakened, it became clear that a new governing document was needed for a free India. The journey towards this began with a series of political reforms introduced by the British, such as the Government of India Acts of 1909, 1919, and 1935. These acts gradually introduced elements of self-governance and created legislative bodies. They were like training wheels for a nation learning to rule itself. They provided the foundational experience in parliamentary procedure and administration that would be crucial for the leaders of independent India. These acts were the stepping stones towards the ultimate goal, a constitution written by Indians for Indians. The monumental task of drafting this constitution fell to the Constituent Assembly, a body of elected representatives from all over the country. They first met on December 9, 1946. This assembly was a microcosm of India itself, diverse, vibrant, and full of brilliant minds. It included leaders, scholars, and visionaries from every walk of life. They debated every clause, every word for nearly 3 years. They drew inspiration from the constitutions of other nations, the parliamentary system from Britain, the Bill of Rights from the United States, and the directive principles from Ireland. But they did not simply copy-paste. They adapted these ideas to India's unique social, cultural, and political realities, creating a document that was truly our own. At the heart of this historic effort was one man, Dr. Bhimrao Ramji Ambedkar. As the chairman of the drafting committee, he was the chief architect of the Indian Constitution. Dr. Ambedkar was a brilliant jurist, a social reformer, and a champion of the oppressed. Having faced the bitter sting of caste discrimination himself, he was determined to create a constitution that would dismantle centuries of inequality and injustice. He masterfully steered the committee through complex debates, reconciling conflicting viewpoints and ensuring that the final document was a charter of social revolution. He envisioned a constitution that would not just be a set of rules for the government, but a powerful tool for social transformation, a promise of equality and dignity for every single citizen. On January 26, 1950, the Constitution of India came into effect, and India became a sovereign, democratic republic. This was not just a transfer of power, it was the birth of a new legal order. The Constitution became the supreme law of the land. Any law that was inconsistent with its provisions was declared void. It laid down the fundamental principles of governance and guaranteed certain basic rights to all citizens. It was a declaration of faith in the Indian people, a bold and ambitious blueprint for a future free from the shackles of the past. The Constitution was a promise of justice, liberty, equality, and fraternity. The long and arduous journey from Manusmriti to the modern republic had reached its most important milestone. The Constitution of India is not merely a legal document, it is the soul of the nation. It establishes a framework for a society that is both democratic and just. One of its most crucial features is the guarantee of fundamental rights, enshrined in Part 3 of the document. These are not ordinary rights. They are the basic human rights that are considered essential for a person's development and are protected by the highest court of the land. They include the right to equality, which forbids discrimination on grounds of religion, race, caste, sex, or place of birth. The right to freedom, which includes freedom of speech and expression. The right against exploitation. The right to freedom of religion. Cultural and educational rights. And the right to constitutional remedies, which allows any citizen to go directly to the Supreme Court if their fundamental rights are violated. Another foundational pillar of our legal system is the principle of separation of powers. The framers of the Constitution were wise. They knew that concentrating too much power in one body could, lead to tyranny. So they divided the powers of the state among 3 distinct branches: the legislature, which is the parliament and state assemblies, which makes the laws; the executive, which includes the president, prime minister, and the council of ministers, which implements the laws; and the judiciary, which is the courts, which interprets the laws and resolves disputes. While these branches are separate, they also have a system of checks and balances. For example, the judiciary has the power of judicial review, which means it can strike down any law made by the legislature if it violates the Constitution. This ensures that no branch becomes all-powerful. The judiciary, headed by the Supreme Court of India, stands as the ultimate guardian of the Constitution and the rights of the people. The Supreme Court is the highest court of appeal in the country. Its decisions are binding on all other courts. It has the power to interpret the Constitution and to ensure that both the central and state governments function within their constitutional limits. The independence of the judiciary is a cornerstone of our democracy. Judges are appointed through a specific process and cannot be easily removed, which allows them to make decisions without fear or favor. This independent judiciary acts as a powerful check on the executive and legislative branches, ensuring that the rule of law prevails. Beyond these core principles, the Constitution also lays out the structure of our government, defining India as a union of states with a federal character. This means that power is divided between the central government and the state governments. Matters of national importance like defense and foreign affairs are handled by the center, while matters of local importance like police and public health are handled by the states. The Constitution also includes the directive principles of state policy, which are guidelines for the government to follow while making laws. Although not enforceable in court, these principles aim to create a social and economic democracy, urging the state to strive for things like a living wage for workers, free and compulsory education for children, and a uniform civil code. The law is not just what is written in books, it is what the courts say it is. In India, the Supreme Court has played a vital role in shaping our legal and constitutional landscape through its landmark judgments. These cases are not just legal precedents, they are milestones in our nation's journey. One of the most important cases in our history is Kesavananda Bharati versus State of Kerala from 1973. In this epic legal battle, the Supreme Court came up with the basic structure doctrine. The court ruled that while the Parliament has the power to amend the Constitution, it cannot change its basic structure. This includes principles like democracy, federalism, secularism, and the independence of the judiciary. This judgment established the supremacy of the Constitution and put a limit on the legislative power of the Parliament, ensuring that the core identity of our democracy could never be destroyed. Another case that profoundly impacted the lives of ordinary citizens was Maneka Gandhi versus Union of India in 1978. Before this case, the interpretation of the right to life and personal liberty under Article 21 was quite narrow. But in this judgment, the Supreme Court expanded its meaning dramatically. It ruled that the procedure established by law for depriving a person of their liberty must be fair, just, and reasonable, not arbitrary. The court declared that the right to life is not just about mere animal existence. It includes the right to live with human dignity. This opened the doors for recognizing a whole range of new rights under Article 21, such as the right to a clean environment, the right to health, and the right to education. The judiciary has also been a powerful force for social justice. In the case of Vishaka versus State of Rajasthan in 1997, the Supreme Court addressed the issue of sexual harassment at the workplace. At that time, there was no specific law to deal with this problem. In a groundbreaking move, the court laid down a set of guidelines, known as the Vishaka Guidelines, that all workplaces had to follow to prevent and address sexual harassment. These guidelines were the law of the land until the Parliament passed the Sexual Harassment of Women at Workplace, Prevention, Prohibition and Redressal Act in 2013. This case showed that the judiciary could step in to fill a legislative vacuum and protect the rights of the vulnerable. More recently, the Supreme Court has continued to push the boundaries of rights and liberty. In the case of Navtej Singh Johar versus Union of India in 2018, the court decriminalized consensual homosexual acts between adults by striking down a part of Section 377 of the Indian Penal Code, a colonial-era law. The court held that discriminating against individuals on the basis of their sexual orientation was a violation of the fundamental right to equality. Similarly, in the right to privacy case, Justice K.S. Pottaswamy, retired, versus Union of India in 2017, a 9-judge bench unanimously declared that privacy is a fundamental right. These judgments show how the Indian judiciary has evolved into a progressive institution, constantly interpreting the Constitution to meet the changing needs of society. Independence was just the beginning. The real challenge for India was to transform its colonial legal system into one that served the aspirations of a newly free people. The Parliament of India has been instrumental in this process, enacting a series of laws to bring about social and economic change. One of the earliest and most significant areas of reform was Hindu personal law. The traditional laws were seen as discriminatory, especially towards women. Under the leadership of Prime Minister Jawaharlal Nehru and Law Minister Dr. B.R. Ambedkar, the Hindu Code Bills were introduced. After much debate, they were passed as 4 separate acts in the 1950s: the Hindu Marriage Act of 1955, the Hindu Succession Act of 1956, the Hindu Minority and Guardianship Act of 1956, and the Hindu Adoptions and Maintenance Act of 1956. These laws modernized Hindu personal law, outlawed polygamy, and gave women rights to divorce and inheritance. The quest for social justice led to the enactment of several laws aimed at protecting the weaker sections of society. The Untouchability Offences Act of 1955, later strengthened as the Protection of Civil Rights Act, was passed to eradicate the inhuman practice of untouchability. To further protect marginalized communities, the Scheduled Castes and Scheduled Tribes Prevention of Atrocities Act was passed in 1989. This law provided for stringent punishments for crimes committed against members of these communities. In a similar vein, laws were passed to protect the rights of workers, such as the Minimum Wages Act and the Factories Act, ensuring fair labor practices and safe working conditions. These laws were a direct attempt to fulfill the promises of equality and justice made in the Constitution. In recent decades, the focus of legal reform has shifted to new challenges. The rise of the information age brought with it the need for new kinds of laws. The Information Technology Act of 2000 was enacted to deal with cybercrime and to provide a legal framework for electronic commerce and e-governance. This law has been amended over the years to keep pace with the rapidly changing world of technology. Another landmark reform was the Right to Information Act of 2005. This powerful law empowered ordinary citizens to demand information from government bodies, bringing transparency and accountability to the functioning of the state. It has become a vital tool for activists, journalists, and citizens to fight corruption and hold the government answerable. The legal system has also responded to the changing needs of the economy and the environment. Economic liberalization in the 1990s led to a host of new laws related to competition, foreign investment, and intellectual property. The Competition Act of 2002 was passed to prevent monopolies and promote fair competition in the market. To protect India's natural heritage, the government enacted strong environmental laws like the Environment Protection Act of 1986 and the Forest Conservation Act of 1980. These laws, along with the establishment of bodies like the National Green Tribunal, show a growing recognition that development must be sustainable. This continuous process of legal reform shows that Indian law is not static. It is a living, breathing system that evolves to meet the challenges of a new era. The Indian judicial system today is a vast and intricate structure designed to deliver justice to over 1 billion people. It is a unified and integrated system with a clear hierarchy. At the very top sits the Supreme Court of India, located in New Delhi. As the apex court, its decisions are the final word in any legal dispute. Below the Supreme Court are the high courts. Each state or a group of smaller states and union territories has its own high court. These are the highest judicial bodies in the states and have wide powers, including the authority to issue writs to enforce fundamental rights. They supervise the functioning of all the subordinate courts within their jurisdiction, ensuring that justice is administered properly throughout the state. Below the high courts is a network of subordinate courts, which form the backbone of the judicial system. These are the courts where most people have their first encounter with the law. This subordinate judiciary is broadly divided into civil and criminal courts. On the civil side, the hierarchy usually begins with the court of the munsif or civil judge, junior division, followed by the court of the sub-judge or civil judge, senior division, and then the district court, which is the highest civil court in a district. On the criminal side, the hierarchy includes the courts of judicial magistrates and, at the top of the district level, the court of the sessions judge. This structured pyramid ensures that there is a clear path for appeals, allowing a person who is not satisfied with a lower court's decision to appeal to a higher court. Alongside the traditional court system, India has also developed a number of specialized tribunals and quasi-judicial bodies. These are set up to deal with specific types of cases and to reduce the burden on the regular courts. For example, the National Green Tribunal, or NGT, was established to handle cases related to environmental protection. The Central Administrative Tribunal, or CAT, deals with disputes concerning government employees. There are also tribunals for tax, company law, and debt recovery. These bodies are staffed by experts in their respective fields, which allows for faster and more specialized adjudication. They play a crucial role in the modern legal landscape, providing expert justice in complex areas of law. However, the formal court system is often slow, expensive, and overburdened with a massive backlog of cases. To address this, India has been actively promoting alternative dispute resolution mechanisms. These are ways of resolving disputes outside the courtroom. The most common forms of ADR are arbitration, mediation, and conciliation. Lok adalats, or people's courts, are another important innovation. These are informal forums where disputes are settled amicably through compromise and settlement. They are particularly effective in resolving smaller civil and family disputes quickly and at a low cost. These alternative methods are helping to make justice more accessible and affordable for the common person, offering a path to resolution without the long and often stressful process of a formal trial. The legal history of India is a remarkable saga of continuity and change. It is a journey that began thousands of years ago with the concept of Dharma and has traveled through the complex dualities of medieval rule, the revolutionary overhaul of the colonial era, and the visionary constitutionalism of a free nation. From the ancient edicts of Ashoka to the modern judgments of the Supreme Court, the central theme has always been the quest for justice. The Indian legal system today is a rich mosaic, a blend of ancient traditions and modern principles, of indigenous customs and global influences. It is a system that tries to balance the rights of the individual with the needs of a diverse and complex society. The journey has not been without its challenges. The system is often criticized for its delays, its costs, and its complexities, which can make justice feel out of reach for many. The backlog of cases in our courts is a serious concern that affects the very foundation of the rule of law, because, as we all know, justice delayed is justice denied. The tension between personal laws and the constitutional goal of a uniform civil code remains a sensitive and unresolved debate. Issues of corruption, the need for judicial accountability, and the challenge of making the law accessible to the poorest and most marginalized sections of society are ongoing struggles. These are the hurdles that our legal system must overcome in the 21st century. Yet, despite these challenges, the Indian legal system remains a beacon of hope for millions. It is a vibrant and dynamic system, constantly evolving through legislative action and judicial interpretation. The judiciary, particularly the higher courts, has often acted as the conscience of the nation, protecting the rights of citizens, holding the powerful accountable and expanding the horizons of freedom and dignity. The commitment to the rule of law and the principles enshrined in our Constitution have remained the bedrock of our democracy. The system has shown a remarkable capacity for self-correction and adaptation, responding to the changing social, economic, and technological realities of our time. In the end, the story of Indian law is the story of India itself. It is a story of an ancient civilization striving to build a modern, inclusive, and just nation. The path ahead is long and requires constant vigilance, reform, and a collective commitment to the ideals of our Constitution. The quest for perfect justice may be endless, but it is a quest that defines us as a people. It is a promise we made to ourselves, a promise to build a nation where every citizen, no matter how humble, can seek and find justice. It is a promise that we must continue to strive for every single day, because in a just society, no one should have to say, "Be careful, be alert, be safe."